I walked into my own business on a Tuesday morning and found the locks changed. Every single one of them. My key didn't work on the front door, the side entrance, or the loading bay around back. The company I had built from a salvaged $8,000 personal loan. And 4 years of 60-hour weeks was sitting right in front of me, and I couldn't get inside. My business partner, my father-in-law, had beaten me there by about 20 minutes. What happened in the next 4 hours ended up on the front page of the Austin Business Journal. My name is Caleb, and at 34 souls I thought, standing at the peak of everything I had ever worked for. Instead, I was standing on a concrete sidewalk in 30-degree January air, staring at a dead bolt that used to open when I touched it, trying to breathe through the kind of anger that makes your vision blur at the edges. Before I go any further, I want to know where you're watching from. Drop it in the comments. And if you've ever had someone use your own trust against you, to steal what you built, hit like and subscribe. You're going to want to see how this ends. I should back up a little, because none of this makes sense without context. 4 years earlier, I had co-founded a boutique commercial refrigeration company with my wife's father. His name was Gerald. He was 61, retired from a long career in HVAC distribution, and he had the kind of deep industry connections that take a lifetime to build. Restaurant, groups, hotel chains, hospital supply contractors across Central Texas. I had the technical certifications, the equipment knowledge, and the drive. He had the Rolodex. We shook hands, signed a partnership agreement, and split ownership 50-50. For the first 2 years it worked. We landed our first major contract with a regional grocery chain, expanded to a second service van, hired 3 technicians. My wife was proud. Gerald would come to Sunday dinners and toast to what we'd built together. He called me son in front of his golf buddies. What I didn't know at the time was that Gerald had a gambling problem. Not the kind you see in movies. No casino floor, no poker chips scattered across a felt table. His was quieter and more dangerous. Offshore sports betting accounts. The back room of Saks card game sesh. In the back rooms of certain restaurants we serviced. And a loan from a man in Dallas. That only people with no other options ever agree to. I didn't find out about any of that until much later. What I did notice, starting around month 26 of our partnership, was a slow, deliberate shift in how Gerald talked about the business. He started using words like restructure and consolidation. He suggested we move the company accounts to a new bank. His bank, the one where he had personal relationships with the branch managers. He asked me to add him as a secondary signatory on our equipment purchase lines of credit, explaining that it would streamline things when I was out on service calls. I trusted him. He was family. My wife adored him. My daughter called him Pop. I signed what he asked me to sign, because I thought he was protecting us both. He was protecting only himself. On the Monday night before everything collapsed, I got a call from our longest tenured technician. A guy named Walt, who had been with us since the beginning. Walt told me he'd gone back to the shop after hours, to pick up a manifold gauge he'd forgotten, and he found Gerald in the office with a man he didn't recognize, going through the filing cabinets. When Walt asked what was going on, Gerald told him to go home. Walt called me instead. I didn't sleep that night. The next morning, I got in my truck at 6:15 and drove to our facility on the east side of Austin. The sun wasn't fully up yet. The parking lot was empty except for one car I didn't recognize. A black Cadillac Escalade with Dallas plates. And when I tried my key on the front door, it slid in and stopped. The lock had been rekeyed. I stood there on the sidewalk holding my useless key and felt something go very cold inside me. I called Gerald. He answered on the second ring. And his voice had a quality I had never heard before. Calm in the way that a man is calm when he's already made a decision. And just needs to get through the conversation. He said good morning like nothing in the world was wrong. Asked him why my key didn't work. There was a pause. He said there had been a security concern. He didn't specify what. And he'd had the locks changed as a precautionary measure. He said he was planning to call me later that morning to discuss some changes he wanted to make to the partnership structure. He told me not to worry. I told him I was standing outside the building we co-owned and I couldn't get in. And I needed him to come down here right now and explain himself in person. He said he'd be there in an hour. I knew better than to just wait. I spent that hour sitting in my truck making phone calls. First to my attorney. A woman I'd used for contract reviews when we first set up the partnership. Her name was Donna. And when I told her what was happening, she told me to document everything. Don't enter the building if I couldn't do so without forcing entry. And don't sign anything Gerald put in front of me under any circumstances. Second call was to our company accountant. He picked up on the fourth ring, and the moment I said, Gerald's name, his voice went flat. He told me he'd received a call from Gerald 2 days prior, asking for a summary of the company's liquid assets and accounts receivable. He had provided it, assuming it was routine. He apologized. I told him to pull up every transaction from the last 60 days and send it to me, and to Donna simultaneously. Third call was to my wife. That was the hardest one. She didn't say anything for a long moment after I finished explaining. Then she asked me if I was sure. I told her. I was standing outside a building I co-owned with a key that no longer worked, and yes, I was sure. She was quiet again. And then she said something I will never forget. She said, "He's done this before." I asked her what she meant. She said that 10 years ago, before I was in the picture, Gerald had borrowed a significant amount of money from her mother's inheritance account without asking, and had paid it back slowly over several years, telling her mother it was a short-term loan he'd forgotten to mention. She had never told me because she thought it was in the past. The ground shifted under my feet in that truck. Gerald arrived at 9:15. Not 1 hour later but closer to 2. He pulled into the lot in his own truck, and behind him came a silver Audi, driven by a man in his mid-50s, wearing a sport coat over a collared shirt. They walked toward me together, Gerald with his hands in his jacket pockets, the other man carrying a leather portfolio under one arm. Gerald introduced the man as a business consultant he'd brought in to help with what he called a structural realignment of the company. The consultant's name was Philip, and he had the practiced warmth of a man who spent his career delivering bad news to people and making it sound like good news. I asked Gerald directly, "Why couldn't I get into my own building?" Gerald sighed. He said there had been some concerns about certain decisions I had been making, operationally. He mentioned, vaguely, overextended contracts and vendor relationships he didn't agree with. He said he had consulted with Philip, and they had determined it was in the company's best interest to temporarily suspend my access, while they conducted an internal review. He said this was not personal, it was a business decision. I asked him who had authorized that review. He said he had, as a 50% owner, with signatory authority over the accounts. I kept my voice completely level. I had learned a long time ago, from years of managing equipment failures in the middle of restaurant rushes, that the moment you let the pressure show is the moment you lose control of the situation. I looked at him and said that I was going to need him to put everything he just told me in writing. Signed and dated, right now. Philip started to say something about scheduling a formal meeting, but I cut him off. I told him I wasn't asking for a meeting. I was asking Gerald to write down, in his own hand, the specific reasons he had excluded me from our shared property, without my knowledge or consent, so that we both had a record of this conversation. Gerald looked at Philip. Philip gave a small shrug. Gerald pulled out his phone instead of a pen, and said he'd have his attorney send over a formal letter. I told him that was fine. And then I told him that while we were waiting on that letter, I was going to need him to explain something to me. I pulled out my phone, and opened the email our accountant had just sent through. 60 days of transactions. There was a wire transfer from our operating account, $47,000, made 4 business days ago to an LLC registered in Delaware, that I had never seen on any of our vendor lists. There was a second transfer of $22,000 the week before that, to a different entity I didn't recognize. There were 3 equipment lease agreements that had been modified without my signature. Gerald had used the secondary signatory authority I'd granted him to unilaterally amend terms I had never reviewed. I turned my phone so both Gerald and Philip could see the screen. I asked Gerald what those 2 wire transfers were for. The consultant took a small step backward, as if he needed to create physical distance from what was about to happen. Gerald looked at the phone. His jaw tightened slightly. He said those were vendor prepayments for a new contract he was developing, and hadn't had a chance to brief me on yet. I said the LLC names weren't vendors I recognized. He said they were new relationships. I said I'd be checking the Delaware Business Registry during the drive home. His eyes flickered, just for a second. That flicker was all I needed to see. I put my phone back in my pocket and looked at Philip. I asked him what exactly his engagement with Gerald involved, who was paying his fees, and what he had been asked to deliver. Philip started his smooth, professional non-answer, and I let him get about 3 sentences in before I told him that if he had been retained to advise on a forced buyout or restructuring of a partnership in which I held equal ownership, he needed to understand that any action taken without my consent could constitute conversion of business assets, which is a civil tort, and that depending on what those wire transfers were for, we might also be talking about a breach of fiduciary duty and potentially wire fraud. I wasn't a lawyer, but Donna had spent 15 years in business litigation before she went boutique, and she had given me a very useful education over the phone that morning. Philip closed his portfolio. He said he appreciated my perspective and suggested we all take a beat and let the attorneys talk. He said that reasonable people could resolve this without things getting contentious. I told him things were already contentious. I just happened to be the only one in the parking lot who wasn't panicking about it. That was when Gerald's composure finally cracked. He stepped toward me and dropped the tone of measured business speak entirely. He said I didn't understand the pressure he'd been under. He said the company's growth had created financial obligations he hadn't anticipated, and he had made some decisions to bridge a gap. and had planned to tell me about it once the situation stabilized. He said he had done it to protect us both. He said the least I could do was show some understanding, because he was my wife's father. And he had given me the opportunity of a lifetime, when nobody else would have taken a chance on a kid, with a tools certification and a business plan on a napkin. I let him finish. I said, "You used our company's operating capital to cover personal gambling debts, didn't you?" The silence that followed was so absolute I could hear traffic from the highway 2 blocks away. Gerald looked like I'd hit him with something physical. His face went gray. Philip stared at his shoes. A crow landed on the top of the chain-link fence behind them and just sat there. Gerald didn't say yes. He didn't need to. The silence was a confession, and we both knew it. I told him I was going to go home, sit down with my wife, and that he should expect a call from Donna before noon. I turned and walked back to my truck. He called after me once. He said my name, just my name, in a voice that had all the air let out of it. I got in my truck and drove away. I want to be honest about the drive home, because this is the part I don't think most people talk about. I wasn't triumphant. I wasn't angry in the sharp, energizing way. I was something closer to hollowed out. Gerald had been at our Thanksgiving table. He had held my daughter when she was 2 days old. He had stood next to me at our ribbon-cutting ceremony and shaken my hand, and told me we were going to build something real together. The betrayal wasn't clean or simple. It was layered and personal, and it hurt in a way that no legal outcome was ever going to fully fix. But I knew something that Gerald didn't know yet. 2 months before all of this happened, I had been approached by a regional financial services firm that was building a portfolio of specialty trade businesses in Texas. They had been watching our company's growth for 18 months. They wanted to acquire a controlling interest. I had been quietly exploring the offer on my own, as I was legally entitled to do, and as part of that process I had authorized a third-party valuation of the company's assets. That valuation had given me a forensic-level view of our books, which is how I had been able to identify the anomalous wire transfers so quickly when the accountant sent them over. I had seen the account structure clearly enough to know what didn't belong. I had also, 2 weeks prior, quietly moved my personal equipment certifications and all client relationships I had originated independently into a separate sole proprietorship registered in my name. Donna had advised me to do this when the acquisition conversations began, as a standard protective measure. It was entirely legal. It meant that if the partnership dissolved for any reason, I retained rights to my own professional credentials and the client accounts I had built. Gerald had locked me out of the building. What he didn't know was that the building was one of the least valuable things he controlled. I sat at the kitchen table with my wife for 3 hours that afternoon. She cried twice. I didn't, but not because I wasn't feeling it. I just needed to stay functional. We talked about her father in a way we had never talked about him before. She told me more about the money he'd taken from her mother's account. She told me she'd seen signs over the years. The new truck he couldn't explain. The vacation he'd said was a gift from a vendor. The way he'd gone quiet whenever the subject of money came up in family conversation. She had managed to love him anyway because he was her dad, and because she wanted to believe the pattern had stopped. She asked me what I was going to do. I told her I was going to do what I always did when something broke. I was going to fix it correctly, in the right order, and make sure it never broke the same way again. Donna filed an emergency civil motion that evening, seeking a temporary restraining order to prevent any further asset transfers from the company's accounts, and to compel Gerald to restore my access to the business premises, because the Delaware LLC wire transfers and the modified lease agreements constituted clear evidence of unilateral misappropriation of jointly owned partnership assets. The judge granted the TRO the following morning. By 10 o'clock on Wednesday, a sheriff's deputy accompanied me to the facility, and the locks were changed back, this time with a locksmith of my choosing. Gerald's key was the one that no longer worked. The acquisition firm had asked me to keep their interest confidential, but at this point, I had no reason to protect anyone's timeline but my own. I authorized Donna to disclose the offer formally in the legal proceedings. What that disclosure revealed was that the company, our company, the one Gerald had tried to quietly dismantle to cover his debts, was valued at $2.3 million. Gerald had wire transferred $69,000 out of an asset worth $2.3 million. He had gambled his entire half of a multi-million-dollar enterprise to cover debts that, by comparison, were almost insultingly small. When Donna presented the valuation in the TRO hearing, Gerald's attorney went quiet in a way that said the number was news to him too. Gerald himself sat at the defense table, looking like a man who had been told the car he sold for scrap was actually a collectible. The miscalculation was almost tragic, if you weren't the one who'd had a key that stopped working on a Tuesday morning. The legal process took 4 months. Gerald's attorney tried 3 different angles, argued that the wire transfers were authorized vendor payments, argued that my independent sole proprietorship registration constituted a competing business in violation of our partnership agreement, argued that the acquisition offer I'd received created a conflict of interest that should invalidate my claims. Donna dismantled each one methodically. The Delaware LLCs were traced through the registry to shell companies connected to Gerald's personal creditor in Dallas. The sole proprietorship had been registered after the acquisition approach, not before, and contained only credentials and client relationships I had originated independently. The conflict of interest argument failed because I had disclosed the offer to all parties within 48 hours of the TRO hearing. What nobody expected was what happened 6 weeks in, when Gerald's creditor in Dallas, the man with the informal loan and the unfavorable interest rate, decided he had waited long enough and filed his own civil claim against Gerald for recovery of approximately $190,000 in outstanding debt. That filing became public record. Gerald's attorney had been trying to frame him as a savvy business owner who'd made some operational misjudgments. The Dallas filing made that framing collapse publicly and completely. I found out about it the same morning it hit the court docket. From a reporter at the Austin Business Journal, who called me for a comment. She had been following the TRO filing and the subsequent business valuation disclosure. And now she had the Dallas creditor story. And she was putting together a piece about partnership disputes in the local small business community. I agreed to a brief on-record interview. I kept it factual and measured. I described the timeline of events, the wire transfers, the changed locks, the legal resolution in progress. I didn't editorialize about Gerald. I didn't have to. The documents did that work on their own. The story ran on Friday. By Monday morning, I had received 14 inbound inquiries from other commercial refrigeration clients in the region, 3 of whom had previously worked with Gerald's HVAC distribution contacts and had started hearing things through that network. 2 of those inquiries turned into signed service contracts within the month. The partnership was formally dissolved by court order in late spring. The dissolution agreement, which Gerald signed because his alternatives were significantly worse, transferred his 50% equity stake to me in exchange for a structured payment that discharged his portion of the company debt and released him from further liability in the civil proceeding. He walked away with just enough to avoid a judgment lien on his personal residence. He did not get to keep any of the $69,000 he'd transferred, which was clawed back as a condition of the settlement. His creditor in Dallas settled separately. And that was Gerald's problem and not mine. Philip, the consultant, disappeared from the situation entirely after the TRO hearing. I never heard from him again. The acquisition offer from the regional firm was still on the table after all of it settled. I renegotiated the terms from a position of sole ownership rather than joint partnership, which changed the conversation significantly. I ultimately accepted a partial acquisition. They took a 30% stake in exchange for growth capital and expanded regional reach, while I retained operating control and majority ownership. We signed the agreement on a Thursday afternoon in a conference room downtown, and I drove home and took my daughter to soccer practice like it was an ordinary day. Because, by then, ordinary days felt like something worth protecting. I want to say something about my wife, because she deserves more than a footnote in this story. She testified in the civil proceedings. She gave a sworn statement about the money Gerald had taken from her mother's account years before. The amount, the timeline, the way he'd framed it as a forgotten loan when she found the transfer records. She didn't want to. She cried the night before and told me she felt like she was destroying her own family. I told her she wasn't destroying it. She was just finally seeing it clearly. She sat across the deposition table from her father and answered every question without flinching. I have never been more in awe of anyone in my life. Gerald was required to attend family counseling as part of a deferred judgment arrangement related to the asset misappropriation, and he entered a gambling recovery program. I don't know how that's going. I don't have contact with him anymore. My wife has very limited, careful contact. She calls him on his birthday and at Christmas, and she keeps a boundary around anything that could give him access to our financial life. My daughter, Aunt, knows her pop is going through a hard time. That's all she knows, and that's enough for now. What I kept thinking about in the weeks after everything settled was that Tuesday morning in the parking lot. The way the key didn't turn. The absurdity of being locked out of something you built. There's a particular kind of powerlessness in that moment, when someone who was supposed to be on your side has spent months engineering your removal from your own life. And they've done it quietly enough that you didn't see it coming until you were standing outside in the cold. But here's what I've learned about that kind of powerlessness. It's an illusion they need you to believe. Gerald needed me to see a locked door and conclude I had no options. He needed me to feel small enough to accept whatever terms he and Philip arrived at. What he didn't account for was 4 years of crisis management under commercial refrigeration failure conditions, which teaches you a very specific skill. When something breaks, You don't stand there cataloging how broken it is. You find the nearest working component. And you start from there. My nearest working component was Donna's phone number. Everything else followed from that. I've had people ask me whether I was angry at my wife for not telling me about the money he'd taken from her mother. I want to be clear, no, she carried something complicated for a long time. Because she was protecting a relationship she loved, and because she hoped a pattern she'd witnessed was finished. That's not a character flaw. That's what it looks like to love a parent while also knowing them clearly. If anything, watching her navigate that. The way she sat in that deposition room and chose honesty over protection changed the way I understand what it means to be someone's partner. We are not untouched by what happened. There are Sunday dinners now that feel quieter than they used to. My daughter asks questions sometimes that I don't have clean answers to. The company is doing well, better than well, if I'm being accurate. But there are certain client calls I take where I can hear Gerald's voice in the background of the relationship, and I have to decide, every single time, whether to let that land or let it go. Most of the time I let it go. Not for him, for the version of this company that exists now. On the other side of all of it. The one with a clean ownership structure, a 30% growth partner. And a set of locks that only I control. If you've built something with your own hands, and then watch someone try to take it from you. I don't need to explain why this story matters, you already know. The thing they always miscalculate, the one thing every person who tries to lock you out gets wrong, is that the building was never the point. The knowledge, the relationships, the capacity to rebuild from a parking lot if you have to. That's the part they can't touch. They can change the locks. They can't change what you know.